Mama's in the living room watching Judge Judy. I'm in the kitchen eating leftover sushi, and she yells, "Oh, girl, you gotta hear this one." A man was arrested for running the theme park, and when they said, "Where's your license?" he said, "My dog ate it." Oh, you can't make this shit up. Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout, "Girl, you gotta hear this one." Mama loves to laugh at how absurd life is, says it's all a comedy and I'm her audience. And I love the way she makes fun of the world. She said, "You'll never guess what's with their girlfriend. It was a man who didn't get us out of the bed. He said, I've been through hell and now I need some help. You just can't make this shit up. You just can't make this shit up." Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout, "Girl, you gotta hear this one."
Hey everybody, it's Squid. Welcome back to the channel. So we're gonna get straight into it today. Excuse my skipping the pleasantries and bullshit. I got shit to do. I got somewhere to be literally right after this stream. So I just don't want to get behind over the weekend because we've got other things planned for the weekend. So we've got shit to do. And this document, I don't know how I feel about this document. We are going to talk about Randy's response to the show cause order. Just for reference, this is the Hales versus the Haters case. That's what I'm calling it from now on because it's like trying to explain the name of the case or whatever it is. Fuck. This stream, FYI, will be filled with and laced with a type of language that I'm sure will piss a lot of people off. But guess what? It's my channel, and if you don't like it, sit and rotate. Because I am me. I am not fake. I don't pretend to be anybody else off screen. Yeah, and Nick, don't make, I'm on a diet, right? So like, I have a competition coming up in 2 weeks. So, and that's actually where I have to be because I have to do 4 workouts today. I don't know about all 4 today, but with my partner. So, welcome to the last of my gummy worm pre-workout while drinking a Celsius. This is how I roll. So if you don't see me from now on, it's because I had a caffeine and citrulline heart attack. I think it's going to be a good one. So, yeah, I'm going to sip on that at the end of the stream because I got places to go. The hackers are busy, so be careful. YouTube and other social media are being attacked. Okay, how are they being attacked? Like the chats are being attacked or the creators themselves? Because I'm not really sure how I feel. But we have this little piece of fun today. And I messed up the title. I accidentally labeled this as document 120. Oh, there we go. 122. Never mind. I was right. All right. So we are going to share this. We are going to get started. It's not very long. It's only 11 pages. So we should be able to get through it in an hour-ish. I'm going to make it bigger, but I'm also starting to do this again because my content lands in other places. I have to protect my stream. So we're gonna do it like this. Sorry. There we go. It's what I gotta do to get by. Bored people to text too early. Yeah, Anyway, we are going to do this. I have to bring up my I have stuff for this stream, so I have to I thought about this stream for a little bit. All right. So this document is the second order to show cause that Randy has filed. This is in no way meant to attack any single person. I am not a lawyer. I know this is not Randy's only case. I know that Randy's got a lot of shit. But like, I keep a calendar with like dates and everything written in it because I'm by myself. Like, I'm a one-man show. Even when I'm not a one-man show, I keep a calendar. We write everything down so we don't forget dates, timelines, even 90 days out, 2 weeks out. I will write down, this is due, this is due, this is due. Randy's not a one-man band here. So why this is the second show cause and why after the email was the email service request was denied, did he not file anything else? It's just weird to me. There's some shit that's not adding up on both sides. And some things that I look at and I know I'm not a lawyer, so before you attack me in the fucking comment section, I don't give a shit. I'm gonna give you my damn opinion, whether you fucking like it or not. Because that's why people are here. All right. This is we are focusing with this document on the email service controversy. And the main point of this is, can you serve someone by email if they live in Wisconsin? Randy lives in Florida. Teschendorf lives in Wisconsin. Here's the thing. It really doesn't matter what the laws of Florida are. It matters what the laws of Wisconsin are. So we shall see what this actually looks like in practice. We shall see. Yeah, one-man show just until baby squid can write. It means they have to prove their case. They have to prove something to the judge. And part of me is, this is a nice try counselor. Kind of going to be a nice try counselor from the response from the judge. All right. Elephant Shoe LLC and Jeremy Hale respectfully respond to this court's order to show cause dated October 14th and request additional time to serve defendant David Michael Teschendorf through substitute service by publication pursuant to Wisconsin Statute 801.11. Despite diligent efforts, plaintiffs have made unable to serve defendant Teschendorf due to his deliberate evasion of service, which constitutes good cause for an extension under FRCP 4M. Oh, did it lock? Yes, you can try, but you tried, but you're gonna lock this all out of the laptop. If you keep, don't let it lock.
No, I can't. Mommy, I can't.
You did it.
No, I can't.
It's okay, Angel. All right. And just for reference, because I hate let's see.
like that.
For reference, we have (801.11) here, and FRCP 4 here. So we have references, and also we have slides, because, you know, just how I am. Also, there are a few things that just do not make sense to me as a non-lawyer. Like I said, non-lawyer. So we're just getting into it as a non-lawyer. However, there are some things that just don't add up from a common sense and logical perspective that I cannot figure out. And we will be discussing.
Mommy?
Angel, why'd you close it? She's obsessed with the laptop. So, I did not actually want to stream till 2, but because it kind of screwed up my flow for the day. However, you know, it is what it is. So, I'm trying to. Legal standard 4M governs the time limit for service in process of federal courts. The rule provides that if the defendant is not served within 90 days after the complaint is filed, the court must dismiss the action without prejudice against the defendant or order that the service be made within a specific time. Catulli versus Ellie, 11th Circuit, 2021. However, if the plaintiff shows good cause for the failure, the court must extend the time for service time as appropriate. Even in the absence of good cause, the 11th Circuit has explicitly held that Rule 4M grants discretion to the district court to extend the time for service of process. This discretionary authority was established in Hornekamp v. Winkle, 11th Circuit, 2005, where the court recognized that the 1993 amendment to Rule 4M permits district courts to extend the time for service even when the plaintiffs have not shown good cause. We have a couple of things here. He's citing case law. Fine. However, and it might be good case law with the 11th Circuit. However, Tetchendorf doesn't live anywhere where the 11th Circuit covers. Tetchendorf lives in Wisconsin. And in service rules, the federal courts have defaulted to state legislatures and state laws of how to serve individuals living in their jurisdiction. So FRCP 4M can say whatever the fuck it wants to say. It doesn't overrule. It does not overrule Wisconsin not allowing email service. And just because Florida does, even if Florida does, say there's been controversies. I've heard people mention yesterday, I heard people mention that some people brought up case law where individuals in Florida could be served. Teschendorf doesn't live in Florida. So even the Florida rules of how it is legal to serve someone in Florida do not apply. Do not apply. And that is the the bigger issue with our justice system and our legal and our court system in general is it's so complicated that service rules are different in each state. So when you have a federal case, you resort to state law. But if you're a Florida lawyer, and this is partially Randy's fault, but partially not Randy's fault, like in a way, in this perfectly my opinion, people can feel free to disagree with me. I don't care. People do anyway. However, it's a bigger court system issue because a Florida lawyer, just like Bubbles coming from Massachusetts and trying to be a lawyer in Florida and doing Florida law, it's there's different laws, different state laws, and if you're a lawyer in Massachusetts, you don't know Florida law very well. It's just outside your. It happened to me when I moved from Wisconsin. I knew Wisconsin law for OTAs very well, what I could and couldn't do legally. Georgia has different state laws as what I can and what I can't do. But it took me time to figure out what those were. And I still don't know all of them because I don't work in that system anymore. However, if you're going to try to serve a defendant who lives in a different state, you might want to know those service laws and know that the Florida law doesn't apply to those people because they don't live in Florida. So this, in my opinion, is a good cause for him to get an extension. And I believe the judge will grant an extension of time and not completely dismiss it. However, I think that there's going to be some bumpy roads, and I don't think Randy's going to get everything he wants. Even in the absence of good cause, even when the plaintiff has not shown good cause. Argument: the court should exercise its discretion to grant an extension under Rule 4M. When a plaintiff fails to show good cause for failing to effect timely service, the district court may still consider whether any circumstances warrant an extension based on the facts of the case. Lapone Dempsey v. Carroll County Commissioners, 11th Circuit, 2007. Only after considering such factors may the district court exercise its discretion to either dismiss this case or direct that service may be effected within a specified time. The 11th Circuit has recognized that an advisory committee note to Rule 4M provides guidance on factors that may justify an extension absent good cause, including if the applicable statute of limitations would bar the refiled action, or if the defendant is evading service or conceals a defect in attempted service. Here, the record clearly demonstrates that defendant Teschendorf is evading service, which is a recognized basis for granting an extension even without a showing of good cause. I completely agree with that. My issue with this whole situation is wrong jurisdiction. Wrong jurisdiction. Defendant Teschendorf is deliberately evading service. Plaintiff filed the initial complaint naming Teschendorf in this action on February 23, 25. Plaintiff made diligent and repeated attempts to serve Teschendorf with the summons and initial complaint, with 4 initial attempts being known to belong to a location to Teschendorf by State Process Servers, Inc. in Wauwatosa, Wisconsin. At each attempt, there was no answer, despite the process server's cards being left. See Exhibit 1. After that, private investigative services were engaged in this matter, and 3 other locations were located for Teschendorf, who, on his YouTube channel and on Defendant Lee's YouTube channel just yesterday, can be seen taunting Hales that he, Teschendorf, has not been served. Even though Teschendorf has also stated that he wants to be a part of this litigation on Teschendorf's own YouTube channel. And that right there is the stupidest thing you can do. That right there is the stupidest thing you can do. And I just have to remove this really quick because I don't want to be accused of shit, even though everybody knows this already. There are certain things that I want to be sure of before I show it. Here we go. All right. So I think that the judge will give him an extension because he's obviously evading service. Obviously. And when you go on, too bad. Go get your iPad. Too bad. In late June 2025, a resident at a location known to belong to Teschendorf told the process server that Teschendorf does not live there, then quickly closed the door. Completed by Vincent Semitaro.
Mommy. See, mommy. See.
I know. And guess what? I gave you 4 chances. You're done. Go get your pad. Temper tantrum incoming. She didn't get away. I received within the process on June 25th, 2025, and that after due diligence and diligent effort, I have been unable to serve said person. The following itemization of the dates and times of attempt details the efforts required to serve. Results, doesn't live there, per tenant, closed door before he would give name. See Exhibit 2. On August 12th, 2025, Teschendorf posted a video on his own YouTube channel, demonstrated full awareness of this pending litigation, commenting on and showing to viewers document number 96 in this case. And there's the link. We're not going to give him any ad revenue or watch time, so sucks to be you. On August 15th, 2025, Teschendorf, upon being advised that a request to waive service was being sent to him, posted a video on his YouTube channel stating, "Plaintiff just wants to serve Dave with court papers, but here's where the law is clear. Refusing to waive service is not evading service. Under FRCP 4D, a defendant has the right to decline a waiver and require formal service. There's no penalty for exercising that right beyond possibly paying the cost of service." Hi, baby. That's it. Once again, a YouTube link that I'm not clicking on because we are not giving him any ad revenue. You're fine.
No, that.
Angel, you want my computer. I gave you my computer. You let it lock 4 times. That's all. That's an extra strike. In baseball, you would already be out. Between August 13th, 2025 and September 8th, 3 additional attempts were made to personally serve Teschendorf, with each attempt failing and resulting in no answer. The process server assigned by the Milwaukee County Sheriff's Office concluded subject avoiding per webcast. See Exhibit 3. Due to the above, plaintiff has reason to believe Teschendorf is deliberately evading service of process. Plaintiff has knowledge that the Teschendorf regularly uses that email address for personal and business, as evidenced by Teschendorf's YouTube page. And then the link, which once again, we're not giving him any airtime because no. Email recently sent to the present by co-defendant Mr. Bonebrake Jr., a copy being attached to his Exhibit 4, request for waiver of service pursuant to FRCP 4D, were emailed and sent via USPS priority mail to Teschendorf. The email was sent to that email and was not rejected. Exhibit 5. Teschendorf was thus advised in advance via this email of what was being sent to him, and the result was that USPS mail was returned to plaintiff's attorney marked refused. Exhibit 6. The evidence strongly indicates that Teschendorf is deliberately evading service of process as shown above. 1. Plaintiffs have made multiple attempts to serve Teschendorf at various addresses known to belong to him, with all attempts being unsuccessful. The process server from the Sheriff's Office concluded that subject is avoiding per webcast after 3 additional failed service attempts between August 13th and September 8th. Teschendorf demonstrated full awareness of this pending litigation by commenting on and showing court documents from this case on his YouTube channel. Yeah, it's very hard to say, well, I don't know I'm being served and I'm not evading service when you already know about it. Tischendorf explicitly acknowledged the service attempts on his YouTube channel, stating that refusing to waive service is not evading service. No. And that defendant has the right to decline waiver and require formal service. No. Y'all, she wants my laptop because she wants to type in the like Microsoft Word, but she keeps closing the laptop because she thinks it's cool and letting it lock and wants me to continuously unlock it. She has an iPad that she knows how to unlock by herself, but she's refusing to use an iPad because she wants to use my laptop. So her temper tantrum right now is a 3-year-old being a 3-year-old, so I'm ignoring it. So I'm not ignoring my child, I'm ignoring the attitude. Just like I'm, never mind. Tischendorf explicitly acknowledged the service attempts in his YouTube channel, stating refusing to waive service is not evading service, and that a defendant has the right to decline a waiver and require formal service. One plaintiff sent a request for a waiver of service via USPS priority mail. It was returned, marked refused. Courts recognize that when a defendant is evading service, this justifies an extension of time of service. A party's efforts to evade service of process justifies an extension of time to effect service. Similarly, in a U.S. CFTC v. Aliaga, Southern District of Florida, 2011, the court ordered alternate service upon defendants who were believed to be evading service. And once again, this is written very well, but it's in my opinion, and like I said, this is my personal opinion. You can feel free to disagree with me, and you can feel free to disagree with me. I think his priorities are off. It's not the judge gave him clearance when he asked by email to serve by email, which I don't think the judge should have ever, hindsight being 2020, I don't think the judge should have ever let him do it, knowing that it's freaking illegal in Wisconsin. Because once again, it doesn't matter what Florida law is here. It doesn't matter what the Northern District of Florida case law is. It doesn't matter what 11th Circuit case law is. It matters what Wisconsin state law is on service of process. I believe that he is evading, and I believe that Randy is doing a good job of explaining that. However, this is beating a dead horse. You said the same shit to the judge. The question is, you got an extension before, so the judge understands that he's evading process, or he's evading being served. The judge understands that. What you are not being effective at, and this is my personal opinion, what Randy is not being effective at is how to alternately serve him effectively. What Randy should have asked for is put it in the paper, because you take an ad out in the paper. At this point in 2025, it doesn't matter that he might not get a Milwaukee Journal Sentinel subscription. That paper is within the jurisdiction of the county he lives in. So suck it up, Buttercup. It's in the paper. You got served. However, this is like, it's well written, but it's well written and wrong. It's like putting the wrong emphasis on the wrong syllable. It is a lot of, you might be smart, but your priorities are all off. Like, oh, and I completely agree, but here's the problem. We talk about all the time on this channel that there is a difference, ethics. There is a difference between what we personally feel as moral and ethical and what is legally defined as moral and ethical. There is a huge difference between there is a yeah, in short, its service isn't about trying to serve Lutheran by email here in Florida. It's about the dude in Wisconsin, an alternative personal service and posting legal notices in media. Yes. And I believe they already made the case, but that's where I had a problem with Randy before, and I still have the problem with Randy, is he's wasted 7 pages of a document on stuff he's already explained to the courts. And the courts already agreed with him on. So instead of wasting all this time and effort and Jeremy's money on explaining why he's evading service of process, which you already did, all you would have to do is put the updates really quick. It's just the wrong. Yes, this is 11 pages, but we're already on page 7, and we still haven't gotten to anything about the fact that he's in Wisconsin and not Florida law. So, and if I'm remembering what I read in this document earlier correctly, he cites all Florida law, no Wisconsin case law. So okay, this is where I have to ignore the chat because I know what you guys are getting at. I'm not stupid. I already read the fucking document. However, you're missing the entire point, which you always do, which is why I'm switching the way I'm doing things, because and there's a thing with that too, because there's arguments in my comments of people telling me that I'm wrong and that there's not a new judge. So, so here, we're just going to turn off chat. There we go. All right. The courts have recognized that when a defendant is evading service, justifies an extension. Yeah, and that's the thing. This is the second time he's had to write a show cause for an extension of time. So the judge already knows all this stuff. And yes, even if it is a new judge, the judge still has access to the entire motherfucking docket and knows all this shit already. The court ordered alternate service upon defendants who were believed to be evading service. This should have been the document that he wrote 3 months ago or 2 months ago. You should have never asked for service by email, knowing that a court has discretion to determine what alternative means of service is appropriate in a particular case. Real Props Incorporated. We commit to the sound discretion of... Yes, ma'am. We commit to the sound discretion of the district court. The task of determining when particularities and necessities of a given case require alternative service of process under Rule 4F3. Courts have permitted alternate service of process through various means, including by email and or service on local counsel. Right here, it definitely could have been a short summary of the avoidance, directly asking permission to extend and post per Wisconsin alternative service rules. Like, that's what, thank you, Jeff, for being my, break it down and put it in words that what I'm trying to express, because I feel like I say it and the chat comes at me by keep reading all the motherfucking time. And it's like, that you're missing my point. I've already read this document. I have Speechify read it to me every morning. Like, Jeremy has to, well, no, that's you're missing the point. In order to serve Teschendorf, you have to follow Wisconsin law. That's the part that I'm trying to express. Because Teschendorf is not in Wisconsin. So Randy has to follow Wisconsin service of process laws 811.11 in order to serve Teschendorf legally. It doesn't matter what Florida law is, it matters what Wisconsin law is. That's what I'm trying to no, they can't. No, they have to use the state of the person that they have to. They have to use the state of the person that the person lives in. Teschendorf is a Wisconsin resident. That's what I've been trying to say for weeks. And everybody comes, well, Jeremy's in Florida. That doesn't fucking matter. Like, yes, because yes, right here, because he's a resident of Wisconsin. Just like in order to serve Bone Break or Bone Crusher, whatever the hell his name is, they had to follow Iowa's service process laws, which didn't seem to be a problem. And I'm wondering if Wisconsin is strict about a lot of weird shit. So, and I like how permit service by email and by regular mail to defendant's U.S. subsidiary and U.S. attorney, track phone wireless. Once again, this is Southern District of Florida. It's Florida case law, and Florida law allows you to serve a business with email. They didn't sue Teschendorf LLC. They sued Teschendorf the individual. So there's another problem. Like there's things here that like my brain, my analytical and like brain breaks down into very basic of information, and it just doesn't make sense to me how someone with a high level of education is having such an issue with it. I understand Randy's frustrated as fuck, because we all are. I get frustrated reading this shit. I just don't want to get behind. Yes, that's Patty, but that's the thing. They never asked for that. You have to ask for alternative service. And in Randy's last motion, the only service he asked for, and I fact-checked this the last time because I literally brought it up side by side when the judge denied the motion, I brought up the request. He only asked to be served by email. He never asked alternative methods in general. He asked specifically by email and was told no, and everybody was all up in motherfucking arms. And then Randy never filed another motion asking for anything. So the judge was like, "It's y'all are beyond your time frame. What are we doing here? Show cause." So, yeah. His residence is in Wisconsin. He's my grandparents. Well, my grandparents passed away, but he's my grandparents' neighbor. I know exactly where he lives. I just live 1,000 miles away from him. Like, but I know, like, I looked at the address and I could literally tell you where that fucking address is and what that house looks like, because I've passed by it when I was little riding my bike. This right here. Yes, Patty, but you're missing my frustration. My frustration was he should have done that. He should have known that Wisconsin laws. Please stop telling me to keep reading, or this, we'll get to that. But you're all missing my fucking point. So, like, I'm sorry. Like, y'all just fuck this shit. Like, this is why this case is interesting from a case law perspective and changing the laws, like service by email. However, it's frustrating because so many people think they know what the damn laws are and have never actually read the damn laws. But people, yeah, small world. That's why I joke and I say he's not Milltown's best. I am, because literally I'm from that same fucking town. Like I've seen all the addresses that have been found for him, and I can name somebody that lives within like 3 miles. So, yeah, the magistrate denied email service. Why does Randy argue the point stating legal cases relating to corporations? That's what I can't understand, and that's what's frustrating. Like that's what's frustrating. Like. That's what's frustrating to me. And I'm like, I know he's got a lot going on, but like, we all got a lot going on. And like, I feel like this whole situation was wasting Jeremy's money. Because there was 2 motions that were filed that didn't need to be filed. 2 show cause orders when he could have initially asked that he wasted Jeremy's money. This was a lawyer fuck up, in my opinion. Service by publication, and this is where he gets into it. Service by publication under Wisconsin law. You're on page 8 of 11, and the last page is generally certificate of service and all that shit. This should have been like, hey, he's been avoiding service for 2 pages. This is why. This is the affidavit. He should have said, hey, I know I fucked up, but he should have never mentioned anything service by email, because the judge already said not appropriate. No state law says it's appropriate to serve an individual by email. I think that's wrong as an email, but that's not a judge problem. That's a state legislature problem. This is where I think Jeremy should be using his platform to be like, hey, we need to change the laws, and like, doing like a call-in stream or a everybody get your shit together. We're going to do a action stream, and everybody's going to write their state legislature and wonder and ask why they haven't changed the laws. Because sometimes if it ain't broke, don't fix it. So the legislature won't change anything if they don't know anything's wrong. So sometimes you have to get your fingers and your hands in motion to write your congressman and ask, hey, this is the problem we're having. Why is this still like this in 2025? Plaintiffs request permission to serve defendant Teschendorf by publication pursuant to Wisconsin Statute 801.11, which provides that if a defendant cannot be served personally or be substituted service with reasonable diligence, service may be by publication. This method is appropriate given the documented evasion of service by Teschendorf. This should have been the whole point of this motion. He's been evading service. Give a synopsis, 2 pages. Give your case law as to why. You've already told the judge as to why. Yeah. This should have been your main focus. You never should have even mentioned email. This last month, I feel like Jeremy's money has been wasted by more than just the anti-what the Hale's ecosystem. FRCP 4E1 permits service of process on an individual by following state law for serving a summons in an action brought in courts of general jurisdiction in the state where the district court is located or where service is made. Since defendant Teschendorf resides in Wisconsin, Wisconsin service laws may be applied. Here's the may. They have to be applied. Wisconsin Statute 801.11 provides that when a defendant cannot be served personally with reasonable diligence, service may be made by publication of the summons as a Class 3 notice and by a mailing of the copy of the summons and complaint to the defendant's last known address. Plaintiffs exercise reasonable diligence in attempting to personally serve defendant Teschendorf, demonstrated by the multiple service attempts demonstrated in the record. Conclusion. Plaintiffs respectfully request that this court find the defendant Teschendorf's evasion of service constitutes good cause for an extension. I believe that they will get this. However, I believe the judge will be a little like, why the hell did this take so long? And it will not be a smooth, it will not be a 1 paragraph, your motion is approved. It will be a fun order to read, in my opinion. I could be wrong and the judge could just say fine, do it. But I believe there will be a little bit of, definitely not as far as sanctions, but there will be a little bit of this was wasting the court's time. This was wasting everybody's time. And that's the problem, alternatively, exercise its discretion to extend time for service in absence of good cause. Grant plaintiff's request for service by publication pursuant to statute 801.11. This is what he should have asked for 45 days ago, or now 50 days ago. Allow plaintiffs an additional 45 days to complete service by publication. And then certificate of service. In Wisconsin, a Class 3 notice requires 3 insertions to a newspaper published once a week for 3 consecutive weeks, with the last publication occurring at least 1 week before the act of the event. So they need at least 21 days. Ugh. See, even bone break goes by a junior. Look at that. Did you notice that? I noticed this before, but it was never a thing until it was never a thing until now. Junior. All right. Getting to these exhibits, we've all seen these. Affidavit. Yeah, all those addresses. The first one, the Cudahy one. It's completely right near me. So yes, this motion should have been 3 pages, maybe 5 to 6, because remember, there's like 3 pages that are certificate of service and conclusion, but like the actual meat of it should have only been like 3 pages, in my opinion. So I believe he's going to I believe he's going to, because it's obvious. Like, it's obvious that he's evading service. I get that. This is where I was kind of getting. I personally feel the entire email reference into this was to diss the magistrate for not approving email to Luthman or whatever the fuck his name is, or Teschendorf. However, the magistrate was correct. Case cited with corporations. Yeah, it's like, if you're going to cite a case to try to prove the judge wrong, because there was no reason, absolutely no reason to cite email in here. Your email request has already been denied due to state laws that are out of the judge's control. Remember, for those of you who don't live in the states, and even for those of you who live in the states, need a refresher on the checks and balances. We have 3 branches of government. The judicial branch is not to make laws. You're not supposed to legislate from the bench. That's a problem these days with a lot of judges. However, it's not the judge's fault that these laws are what these laws are. We have a problem with the laws. We're supposed to go to the appropriate people to change the laws, not yell at and be pissed off at the judge for enforcing and interpreting the laws the way they're written. So, and thank you, Hey Joe, for the $9.99 super chat. Breathe. Thank you. I just feel like I repeat myself, and one of my biggest pet peeves is repeating myself. I don't mind repeating myself to like my child because she doesn't understand, and cognitively impaired, like my stroke patients. I loved working with stroke patients because one, they're generally some of the sweetest people, and most motivated people, but also they don't know any better because their brain is literally injured. And this is where I will wait and see. I have never seen personally in any federal case, when I've seen that motions now go to this judge, I have never seen a judge be removed for one motion or pertaining to one defendant's motions. I personally have never seen that. That's not to say it doesn't exist. But remember, like, here's my case list on Pacer. I'll show you once I get to a spot where I don't dox myself. I have to delete a case, but this is my And all the rest of those exhibits we've seen before. So there's nothing new. That is my PACER case list right now. That's all the cases that I've been looking into. So there's a situation where I've never personally seen that in multiple cases. However, that's not to say it doesn't happen. That's just to say that in my 3 years of experience of having a PACER account now, well, 2.5 years, I have never seen it. I've seen people, and this is where I don't believe chat in essence. And it's no offense to the chat. I have just seen people who I think are very intelligent on both sides. Not that I particularly like, but you can agree that someone is intelligent and still not like them. Like, I can agree that, like, certain people that have law degrees, they're obviously very book intelligent, just not good people. So I've seen people on both sides who I think are very intelligent people and have very good insights and have been right on a bunch of their opinions in the past. Both say that he's permanently gone. And then I've seen people on both sides who I think have some of the weirdest takes and don't listen and think they're always right when they're not. Say that he's only been removed for what, like, I've seen people that I agree with generally and that I think are smart and people that I think are stupid have opinions either direction. So I have absolutely no idea. He is still listed as the referred to judge on the docket. So until that changes, this was always my thought process of why he may be removed from federal 2. One, there is too many defendants. Secondly, he is a magistrate judge, and generally to see a case all the way through, generally magistrate judges don't see a case all the way through unless all parties have consented, like they did in federal 1. All parties consented to having Litho just handle it all. So I think he was removed. I'm thinking he'll be permanently removed from that case, or not removed, but set aside, vacated. Like, hey, you've handled it up until now. Let the district judge who was going to handle if it went to trial anyway, just take over. For these reasons in particular. One, he wasn't the original judge. He was put on it because of the similarities in nature between Fed 1 and Fed 2, between, you know. Second, there's a slight conflict of interest and possibly ethical conflict of interest, in my opinion. And like I said, this is completely just observational. With Bruce being a party in the first case as a lawyer, as representation in the first case, and now a defendant, it would be hard for me, and this is one of the reasons that I'm not a lawyer or not a judge, it'd be hard for me to separate the two of, look how bad I saw you be an asshole, and I saw you be stupid, and I saw you do things that are unethical in the first case. How can I not hold that against you in the second? That to me is a hard thing to do for anybody. Secondly, and this is part of the reason why I think the other reason why sanctions were taking so long before the stay, they were walking a fine line because of the fact that Bruce had already filed a motion in Fed 1 to vacate the judge in Fed 1. Well, now, if he gives sanctions to a party or a lawyer in Fed 1 who is a defendant in Fed 2, Cameron, whatever his name is going to file an instant motion to vacate the judge in Fed 2 because of a conflict of interest. you sanctioned my client in another case, and now you're supposed to be impartial in this case. Third, the absolute disdain and calling the judge a bozo. Yes, Luthman called many other people a bozo, in that none of which I think is appropriate, because there's a difference between what you think and what you say. However, when you put the judge in clown face in a motion going to that particular judge, it would be very hard for me to remain neutral when you personally attack me and then expect me to be an impartial third party. So there's this like one factor after another that is just like pounding down on why I think the judge should be removed from Fed 2. Not Fed 1, but Fed 2. So that's just my thought process. However, we do have a little bit of a, this is my comparative look. And I did make this with a little help, but I did make this because we have to take a look at what's going down and why the US legal system is so damn complicated. Because remember, yes, so Florida versus Wisconsin, a comparative look at service laws. Just an overview, highlight, Cliff's notes. Florida service laws, email service allowed to businesses, not individuals. However, business-friendly regulations. Wisconsin, in this environment, with this governor, not as business-friendly. The last governor, slightly more, still not great, but slightly more. Quick service options, because Florida just seems to get shit done more efficiently than the rest of the country. Like, I don't know if it's the sunshine laws, who runs the state, what they've implemented on like transparency, but Florida, for their many faults and craziness, seems to run slightly more efficiently than the rest of the country. Wisconsin service laws, email service forbidden. There is strict local compliance. Formal service required, and Rule 4E is highly enforced. Highly enforced. There is some very strict reasoning as to why things are done. There's a very, very strict, and all the rest of this we've seen, requests for waiver of service. Yeah. And all of these there's so many addresses in here that it's like so hard to, the whole thing would be redacted pretty much. We've all seen this waiver of service of summons. This was in the last, these are all the same. These are all the same exhibits that were in the last filing, or the last filing. This is just, yeah, pretty much. And it's not a hard concept to understand. It's just a really hard concept to implement. And this is where it gets crazy, because this is where we have to have a larger conversation than just this case. This is where this case fits into a bigger picture, and why this case is so fascinating. Would you believe Belitho would be biased because of Luthman comments and be tainted for Fed 1? No, because Luthman is not a party in Fed 1. The only parties in Fed 1 are Jeremy, John, and Lynette. So I believe the judge would be able to separate that out because he's not an actual party. and the judge really doesn't have, there's not a lot of judges that have social media for this ethical reason. And hey, Rosalind, how are you? So there's a thing here. This is where this case, to me, and this is, like I said, this is my personal opinion. Y'all can feel free to disagree with me, but where this case gets fascinating to me is how this case fits into the larger picture and what we do as a society. What should we do? Because Wisconsin and Florida are not the only states that don't allow process by email. I'm pretty sure that there are no states. There might be one, but there are no states that allow email service to an individual. So it's serve them or dismiss them so my case can get dismissed. John, as respectful as you are in here, I don't think that case is getting dismissed. I apologize. It's just one of them situations where I don't think it's getting dismissed, but I understand why you would want it to move forward to get it over as fast as possible. We can agree with you there. We can agree on that. I mean, we can find common ground somewhere, huh? But I understand why you don't quite want it, you know. Whew. So, just in case y'all haven't heard, this is kind of my workup. So I'm starting a new channel for specifically because the YouTube algorithm doesn't like content that goes in too many different directions. It doesn't know where to push my content out to. So mixing drama and legal and politics streams and all of this, whatever this stuff is, with things that is my pride and joy. I have decided to start a new channel. It is called Evidence Through Motion. It's my passion project. It's my passion project. It's what I went to college for. It's where I feel like I'm not an expert because it's very hard to become an expert in anything, especially a topic as large as the human body, and occupational therapy. But that's kind of my working stuff so far that I've kind of got figured out. So I will be starting to post there. I've updated my schedule because I forgot we have shit to do this weekend. We have family stuff. November 1st is when I'm going to start uploading content. I'm going to kind of get stuff ready before that. So hopefully it'll be an easy transition and rollout. But this is my passion project. The first set of videos will be connecting back to my Ergo Boost on this channel. It will be one video a week and a live stream every Sunday morning where we talk about specifically questions related to that video and that topic. It is my passion project. It's my baby. Now that my baby is not a baby anymore, this is my new baby. I absolutely love occupational therapy. And I'm a licensed therapist, certified nationally. I am no longer certified in this or licensed in the state, and I don't want to practice. So I am not providing medical advice. I'm providing guidance and my corrective exercise knowledge with the hopes of one day starting a business, with doing virtual training and stuff. But then after, does sitting cause pain is our first week's topic. And then there'll be like a 4-week series on fall prevention. So if you are one of those people who wants to move better, wants to live better, wants to feel safer, and wants to age in place, come on over and join us over there. There is no content there right now. There will be, I promise. I'm working on it, but I'm also not wanting to rush it because I want it to be quality because it is my baby. This is my baby. And Robert, thank you for the $2 super chat. Milk fund for the little one. I appreciate that. It's more like chocolate milk fund. And also, for any of you, wish me luck. Wish me luck. I am going to absolutely need it because this is what we are doing today. And this is the competition. Oh, come on. Come on. Why isn't it? All right. This is going to be small because it's not letting me zoom in. So, but this is my, these are my WODs for today. So we are doing, you choose your own adventure, 16-minute AMRAP, you go, I go, 30 double unders or single unders, 5 pull-ups or ring rows, and 5 box overs. Don't let go, 7 minutes, both athletes, 1 rep max of a 1 power clean, 2 front squats, and a hang clean. Boy. Follow the leader, 10-minute AMRAP waterfall style, 10 calorie row, 10 wall balls, 10 sit-ups. And just keep going, 10-minute cap of 100 hang snatches. And every time you switch athletes or you drop the bar, you do 6 synchro lateral burpees over the bar. So if I don't die, yeah. So if I seem a little more agitated, it is because I got roped into doing a competition, and I am a competitive bitch, and now I'm going a little overboard on getting protein, and no sugar. This is the closest thing I'm getting to sugar. So yeah, that's me and my partner are meeting. Yeah, usually I can zoom in on the pictures, and today I couldn't. I don't know why. So, and Harry, thank you for the $5 super chat. Chocolate milk fund. What is this stuff you're talking about? Tomorrow, members only live stream tomorrow afternoon, probably like 5 o'clock. Depends on what happens today, if I die, and when my friend drags me to the gym tomorrow morning. Because it's fall break here, and some of my friends are teachers, so they have the week off. And when they have the week off, it's extra friend time, but it's also extra my friends are gym girlies, so we go to the gym. We go to the coffee shop, and go for 3-mile walks. That's what we do. And Debbie Baker, thank you for the $20 Cash App. For love you. Thank you. Appreciate you so much. I appreciate you guys. And this is where I am going to call it a day. And Philip, wait, hold on. No, and the other day, Tuesday, and I forgot to mention it on yesterday's stream. Philip Small, for pacer, raised in Wisconsin. Son lives near where I used to live. I'm not going to out them, and go Pat go. And if I can translate GPG, I love y'all. Rosalind, I do my sister and brother-in-law about 30 years ago, and they lived in Granada Hills and 3 acres. Someone bought the lot next to them and built a garage on their property. Oh my God. My wife roped me into a 5K a couple years ago, and I thought I was going to have a heart attack. The person who's been roping me into the gym all week has used to rope me into 5Ks all the time, and I think I roped her into a 5K this time. So, looking to adding chia seeds into your diet for extra protein. Yeah, I've been living off chicken breasts. Chia seeds get me because I don't like the texture. I try to put them in yogurt because then they suck up the yogurt and get put that way. But Friday is short for Friday and ends the opposite of sides of something. So friends are opposite Fridays. All right, guys. So just remember, just remember, I know that I cover things, and I cover things in a way that is different from a lot of other people, because I am in the I hate everybody kind of mentality. And I say that with a grain of salt. I don't really hate anyone because hate takes effort. And the only person who is affected by hating someone is the person that is doing the hating. Because at the end of the day, I can say I hate this or I hate that, but does that person really give a shit? Probably not. So remember, being kind is free, staying in your lane is free, and minding your own damn business. And remember, if you talk shit about someone on the internet, there's a good chance you could get sued. Y'all have a great day, and I will see you guys tomorrow for members only. Bye, guys.